Under the Uniform Commercial Code, a party with reasonable grounds for insecurity may demand adequate assurance of the other party's performance. If the other party fails to provide such assurances within a reasonable time, repudiation occurs. In BRC Rubber and Plastics v. Continental Carbon Company, the Seventh Circuit considers what constitutes adequate assurances. BRC Rubber and Plastics, a manufacturer of rubber products, entered into a contract with Continental Carbon Company, a supplier of carbon black, a key component in rubber. Continental agreed to supply BRC approximately 1.8 million pounds of carbon black annually for 5 years, beginning January 1, 2010. The contract set firm baseline prices. During the first 4 months of 2011, Continental supplied BRC with approximately 1.3 million pounds of carbon black. However, Continental then demanded a 2 cents per pound price increase. BRC objected, arguing that the increase violated the parties' contract. Continental continued to demand a price increase and failed to deliver certain shipments in a timely manner. On May 16th, BRC formally invoked Article 2, Section 609 of the Uniform Commercial Code, which allows a party with reasonable grounds for insecurity regarding the other party's performance to demand adequate assurance of performance. If such assurances aren't received, the contract may be deemed repudiated. On May 20th, Continental's counsel responded that the company would abide by the parties' contract. However, over the next several weeks, Continental continued to push for a price increase. On June 2nd, BRC notified Continental that it was treating the contract as repudiated. BRC then secured an alternative supplier and filed suit against Continental. Continental conceded that its conduct gave BRC reasonable grounds for insecurity, but argued that its assurances were adequate. The district court disagreed, holding that BRC was justified in treating the contract as repudiated. Continental appealed to the Seventh Circuit.